All right, welcome everyone. This is Curt and welcome to another edition of Fire Law Roundup for September 12th of 2022, but we're recording on September 11th of 2022. But Brad, go ahead and take us away. We got an interesting week. Go
Yeah,
ahead.
we do some tough cases, but I think as we do, we'll make them easy. First of all, I apologize to everybody for maybe the video quality. Hopefully the audio quality is good. I'm not at the office today where I normally present from, but let's start down from me. And this is in New York State. I'm well familiar with the people involved in the case, but the mother of a New York firefighter who died in the line of duty at an assisted living facility. There's been a number of these. And that death was in 21. She's now suing. She's suing the facility, which is pretty good. She probably should. Its owners, the nursing home's owners, two of the contractors. I don't yet understand that yet. And the village, which is what today's focus on, which is interesting. But the village who's now sued, well, let me say, so the facts are this. So Jared Lloyd, he was 35. He was a volunteer with Spring Valley Fire Department. This was a big fire. It started because, well, as I understand it, it started because some rabbis were down in the kitchen and they were trying to heat some things to make them sterile and kosher. And that started a fire. That's how I understand it.
They were the two rabbis, or I think it was a father and a son, but they were the ones. They were the contractors that were sued.
Oh, okay. And that makes sense. That makes sense. So I think they fled the country. Frankly,
Did they?
No, yeah. The rumor is they took off to Israel and they're out. I don't know that they've ever come back, but that was the rumor. So, you know, I'm close to some of this, not involved.
Well, there were manslaughter charges. I'm not sure if they were the ones. I haven't really followed the civilian side of this, but I know some of the folks were charged with manslaughter for the deaths.
Yeah, and that would make sense. That would make sense. But here, there's a number of suits, but this suit focuses mostly on the village. And I don't think this is going to be successful, but it raises a really interesting question. So one of the things they're doing, and let me explain to the more for New York viewers. Well, I guess this is pretty generic. So as many people know, in volunteer and paid departments, you cannot sue your employer, right? You get workers' comp and you can't sue your employer for pain and suffering or anything else. You just get workers' comp. In New York State, you get the volunteer firefighters benefit law protection, which is like volunteer comp, although a little better. And here, the village is the employer of Jared, or was the employer of Jared, because they're the municipality in control of the fire department. It was a village fire department. The really interesting part of this case is what they're suing the village over are the acts of the code enforcement officer and the village for allowing an allegedly known dangerous condition to perpetuate and keep going. So I look at this really interesting, right? So you can't sue the village for your injuries, your death in this case. But on the other hand, they're suing a department of the village having nothing to do with the kind of village's status as the fire department, but instead as the code enforcement department. So I think, I mean, that kind of sums this up, but I think this is going to be an incredibly interesting case as to whether the compensation prohibition that says you can't sue your employer is going to apply when you're trying to sue your employer, but for a totally different, unrelated reason to the fire department.
Well, it is an interesting, and I'm not as familiar as you are with the facts, but is the fire department a 501c3 nonprofit, or are they a municipal department?
Well, they could be both, right? In New York, as you know, we have crazy laws, which is, I really appreciate.
If you can be both.
You can be both. So the municipality in control is the village. And in a case a while ago, the courts held that you can only sue, or the entity liable for the fire company is never the fire company. It's always the municipality in control. So in New York State, you can only ever go after the municipality in control, which in this case is the village.
And by the way, the municipality has immunity, so you can't sue at all.
Right,
But-
right. Which is where it's going to get really interesting, because now they're looking to sue for violation of code enforcement, or you're allowed to known danger. To me, that's a tough immunity hurdle anyway.
Yeah.
But
It seemed like they were teeing up. They threw out the special duty issue here, which is a sort of an end around some of the public duty doctrine and some of the other protections. And it's almost like I don't see a special duty on the facts.
look, there's no one-on-one relationship between, Jared and and anybody really, right? The village didn't tell him to go in. Maybe it was implicit, it's part of your duties, but he didn't rely on them that this building was safe. And so there's no real obligation or ability of any firefighter to rely on their municipality, right?
Mhm.
Can you imagine if this, and again, I feel horrible for Jared, don't get me wrong.
No, me too. We all do. Yeah.
Has nothing to do with that.
Right.
And nobody should think that, or I'll get, rocks thrown at me every time I go to Rockland. But this isn't about Jared as far as the legal issue goes. But can you imagine if a firefighter could sue the city because the city code enforcement officer failed to provide a safe working place for the firefighter?
Yeah.
That'd be incredible. I
Well,
mean,
one of the cases I use is a case out of the Beverly Hills Supper Club fire, and out of Kentucky. And the Kentucky Supreme Court said you can't sue code enforcement people for failure to enforce the code. That's a public responsibility. It's a public duty, and it won't sustain unless you can show a special duty. It won't sustain a negligence finding. So tough case there.
tough case. One of a few. It's unfortunate. Look, I think they should be suing the rabbis, the contractors, if they can find them or get them, and definitely, probably the nursing home for having a dangerous place. Proximate cause is going to be tough, because how many intervening causes are there in a fire? Okay, fine, it started, but there's a lot of things in between the death and the fire starting. So it's a tough lawsuit, and I feel badly, but
I think it is going to be an easier case against the nursing home as well as the rabbis. I think that it's a much more straightforward case. There may be some defenses, but I think it's more straightforward than against the municipality.
Yeah, and if you remember Black Sunday, those lawsuits, they failed. Right? I mean, they tried to get I believe as I recall, they failed.
No. There was a $181 million verdict. Black Sunday.
It was a criminal law that failed.
Yeah, the criminal side failed. Yeah.
So it's not so far different than that, right? When Black Sunday, where everything was broken up and chopped up, and
I don't know if this applies to volunteers, and we're really getting deep into New York law, so it's really your area of expertise, but you've got a funky law that allows an exception to immunity as well as an exception to workers' comp exclusivity when the government violates a statutory duty. And I see a lot of tort cases out of FDNY going along those theories. But when government, for example, FDNY violates a statute, then it opens some sort of immunity. It's a statutory immunity. It's not negligence. Kind of sounds in negligence, but it's really based on that violation of a statute.
Yeah.
So, perhaps that's what is being alleged here as well.
Well, see, I have not read the entire complaint, but I'm anyway. So, I wish obviously Jared's family some luck on this. I just think they've got a tough road to hoe.
Yep.
Okay, let's go to Oregon. Oregon, back to all our discrimination cases where, and this appears to be a personal vendetta. Here we have we're in Oregon. We have a lieutenant. He claims he was pressured to remove himself from a promotional list for captain. And we'll talk about the reasons, but he files a suit. He says he's been discriminated against based on disability, veteran status, which is what we'll focus on, and whistleblower status we'll focus on as well. And basically what happened is the city undergoes a process and scoring, and the way they were scoring violated giving points, violated the state statute, which gives points for veteran status. He then raises that issue in an email. They correct their scoring process, but apparently that really allegedly, right, upset them. And so allegedly, the battalion chief was very upset, expressed that he was upset, and kind of leaned into him to get him to, and tried to get him to, remove his name. And now he's saying, listen, I did that under duress, but, it was all because of this email where, by the way, I correctly said that, we violated the law. And normally, if you point out something, it's not really a whistleblower case, frankly, but it kind of is. But he's really,
I think you can make the case. There's actually a couple of emails. One, and there's a different aspect. There's a couple of really cool aspects to this. I guess, being a law geek, I guess, cool, but not to the average person. But one of the emails, he criticized the union president. There was an election coming up, and he criticized the union president, and that's protected speech.
Yeah.
That is the employer cannot hold that against the employee. It's like, somebody goes to a union meeting and says that GD effing Chief Barone, he's a pain in the butt and yada, yada, yada at a union hall. I can't retaliate against them.
Right.
You can't, it's protected. And so, the fact that some of the chiefs didn't like what he said in that email, it's a union election.
Yeah. Yeah.
It's protected.
Yeah.
So,
and I question whether I'm assuming the chiefs probably aren't part of the union.
I don't know. But it's a thin line. They probably were at one time. They may still be dues paying members. I know I paid dues well after I was out of the union. So, it's a closed knit society, and they're going to find out about it. And if they happen to support the union president, but management cannot be interfering with union elections. That's you just can't.
And they did.
So,
look,
and I didn't see that really emphasized in the suit. I think that's another, and it wouldn't be veterans. It wouldn't be whistleblower. It would be specifically a violation of concerted activities.
Yeah.
Yeah.
Because you're definitely punishing for speaking out on something that he was right about, and the city admits he's right about.
And then the veterans preference, certainly that would be retaliation. And interesting, USERRA has some protections. That's the military discrimination. This is actually a little bit different. I never really thought about it. This is veteran status discrimination. And some places have, some jurisdictions have, whether it's a state statute, they might have a city charter or city ordinances that say that we will not discriminate against someone because of their veteran status. And so that's a new, it's in addition to military service, it's also a different protected class. So this will be interesting to follow.
Agreed. And look, my 2 cents to everybody: if you're pissed off at somebody and you're in a leadership position, suck it up, Buttercup. I mean, seriously, just to
skin.
Yeah, you cannot be in a leadership position if you're going to be pissed off because everybody does something. Look, you get elected, you have one bar, one bugle, or whatever on your collar. You're a target. It doesn't matter. Just accept it.
I go back to the Reggie Jackson quote, right? They don't boo nobodies.
Yeah, that's true.
They don't boo nobodies.
Say who's that? So, yeah, I agree. Okay. I love this next one. I mean, I hate it, but I love it because we're the Monday morning quarterbacks here, or Sunday night quarterbacks at the moment. But let's go to Alabama. And I don't mean to offend Alabama because this could have happened in Texas too. But
this could have happened anywhere.
Anywhere except New York, where they've outlawed guns and now we're not even allowed to have rubber bands, I think. But nonetheless, we'll see the Supreme Court address that. Okay, so here we have, I got to summarize this because the names will drive you nuts. So there's a neighbor dispute. The neighbors are, pissed off over garbage and all that stuff left in front of somebody's property. The it starts getting whatever heated, and all of a sudden, and the emergency services are called, police and fire, which will lend into another interesting conversation. In any event, so the neighbor who basically was trashing the place, but I think was the subject of the pissed off neighbor's anger. So that neighbor, right, has a relative, son, and
spouse.
Spouse. And guess who shows up on the fire truck? Nonetheless, carrying a gun, but guess who shows up on the fire truck, right? So he shows up on the fire truck. There's pushing and shoving going on. The firefighter, I think, is being pushed, pushing, whatever. But the firefighter pulls a gun.
Oh, did he? Oh, I didn't see that.
That's I'm pretty sure he pulled a gun.
I didn't see a gun pull, Brad. I'm sorry.
Let's see. Hold on. Yeah, Hammock then pulled a gun and pointed, threatening Wander at Cordell's body and head.
Whereabouts is that now? Just
to say, I'm quoting you.
No, I know, but
it says the confrontation with Hammock placed Cordell in fear for his life as Hammock proceeded to use an unauthorized force against Cordell. To wit, Hammock physically and violently assaulted Cordell by pushing him and hitting him in his chest multiple times. Hammock then pulled a gun and pointed it in a threatening manner at Cordell's body.
You know what? I read right past that. My eyes went right over that. I didn't see that in the complaint. Holy crap. You're absolutely right.
Yeah, so I love this one.
Oh my God.
Right. So, and it was the firefighter. That's why I'm not using names because it's too confusing.
Yeah.
The firefighter on duty, but it's Alabama. I don't know. Maybe that's allowed. Pulls a gun. I don't know if he went into his house, but he pulls a gun. In any event, they then arrest the neighbor, not the firefighter, not the firefighter's spouse, right, who had the gun. They arrest the neighbor. They put him in prison. He's alleging, these are, by the way, these are all allegations. This is not a court finding. These are just all allegations, but all these allegations, right? So they then put the initial neighbor who's upset about the garbage and who had a gun pulled on him, etc. They put him in prison. They search his cell phone. They search through some records. They take his personal belongings, right? So now we have the Fourth Amendment allegation. And then they let him go at some point for whatever reason. I think it's because he suffers a medical emergency. He's taken to the hospital. Then he's released by the police after his medical treatment. So he's out. So they sue, right? As kind of understandable, but there's a lot of interesting parts to this lawsuit. And I think more there could have been. So, they say that the city who employs the firefighter was negligent in his hiring, training, and retention. They say the city committed assault, battery, conversion, false imprisonment, and violated Cordell's neighbor's constitutional rights and discriminated against him based on his age and gender. Now, forget that age and gender stuff. I don't get that. But negligent hiring and training, like, hey, don't carry a gun on duty. And if you do, don't pull it unless your life is in danger. And if it's, and by the way, getting pushed when you can walk away probably ain't going to be a life or death situation. When I'm assuming, by the way, and I wondered what happened, what about all the other people on the fire truck? I mean, this is just a great bunch of allegations. I just don't know how true they are, but interesting allegations.
Yeah, I understood the guy was arrested, but I didn't realize that the firefighter pulled the gun. And that raises something. You and we've talked about this at your conference, and it's something that as a Second Amendment guy concerns me greatly. Is that when we carry on duty, if we're carrying on duty, we are government agents. And I know firefighters don't think of themselves as government agents, but there's a difference in when a citizen takes out a gun and threatens deadly force and when a government agent does it. And it raises these constitutional issues, Fourth Amendment, 14th Amendment. And we don't have any training in that. I mean, you and I do, but the typical firefighter doesn't. They spend a great deal of time in police academies and also police refresher on this issue, because even if a police officer places his hand on a gun or her hand on a gun, that is threatened use of force. It has to be justified. If it's not justified, it's considered excessive force. even placing your hand on a gun can
That's
be
threatening.
excessive force, right?
Yeah.
So we're not trained in that. Maybe he is, maybe he's a constable, maybe he's got the training, but you know, it's not what you can get away with as a citizen is not what you can get away with as a government agent. And I hate to use that term, but that's how it looks. I know we don't think of ourselves that way, but it's we work for government, and we're in your house, your property, your whatever, and we're threatening you with deadly force. Holy cow.
Yeah, and there aren't too many states where you can just pull out the gun when you have a whole yard behind you, and right, and you can leave. And I'm not saying just retreat. I mean, you can just take a step back, but there was no cop ever, no good trained cop, whatever, who's being pushed, would ever pull a gun. And, I'm going to quote you, and it's not applicable in this case, but the problem with concealed carry or open carry, whatever it is we don't have anything between our voice and the gun. We don't have a baton. We don't have mace. We don't have a taser. We go right to deadly force. If this is true, wow. I would say the city's probably losing. I don't care whether the arrest was justified or not. One of your employees pulls a gun on you, and no wonder he had a medical condition. If true.
Yeah.
Can't say that enough. And
yeah,
I'm kind of wondering, where's the other
always
people?
There's always another side to it, but
Yeah.
Certainly that firearm. I mean, I was thinking that our discussion, I hadn't picked up on the firearm, and I'm thinking, but even they got into some sort of a physical tussle, even that
Too much.
can be excessive force.
Right.
Because any force that you apply has to be reasonable. And once you go beyond, as a government employee, once you go beyond, it's not just assault.
Let's stop there.
It's a civil rights violation.
But let's stop there, because you just said the key words. As a government employee, you can bet the city is going to move to dismiss, saying he was not acting in the scope of his duty, and we aren't liable for what clearly was him protecting his spouse.
Yeah.
And one of the things they said, which I don't think holds any water, I don't know why they went there, but they said, well, the policy was wait for the police. I don't know that in this case that really matters, but I will tell you, if I'm the city, I'm arguing this has nothing to do with scope of his duty. We're out. Unless they can show you knew he was carrying a gun and you knew he didn't have training, that would bring the city back in, certainly.
Yeah.
So
I guess I was going in the direction of qualified immunity, but I think you're right. The city may find it more advantageous to cut them loose.
I would, but they better not be able to say that even a lieutenant knew, and I assume he's not a lieutenant, but we don't know. But that a lieutenant or somebody higher knew he was carrying a gun. You show that you knew people were carrying a gun, all bets are off.
Yeah, and certainly if he was a peace officer, an arson investigator, that changes a little bit. But now he steps into the shoes of a police officer, and hopefully he's got the Fourth Amendment training on exactly what he can and can't do. Well, again, we got half the story here, but
right. So, okay, let's head to Denver. This is a really good lesson for employers. You give great kudos to documentation,
and they deserve it. The Denver Fire Department deserves a lot of kudos. They did a bang up job on this one.
Yeah. So here, look, these are pretty simple facts, right? They have there's actually two plaintiffs. I don't know what happened to the other. Well, they're still going, but so. And I think they're both probationary firefighters. I don't know anything about the other one.
They both have since departed.
Oh, okay. So here we have a probationary firefighter. She's female, and I believe African American. I'm not totally positive.
Yes.
She did not do very well at the academy, but she did graduate from the academy. She's still on probation when she gets out of the academy, and she says, well, you fired me. I'm going to tell about what she did to get her fired, but she claims she's fired, and you can't do that. You can't fire me. And what the city comes back and does, having really documented every time these people, these probationary firefighters, not just this female, I presume they have a good training and education and documentary history, or history of documenting these things, right? Clearly everybody's involved documenting. So it seems. In any event, so she doesn't do great at the fire academy, but she does graduate. And she first tries to say, listen, you can't use my performance at the fire academy because I graduated. And the court throws us out. So of course we can use your performance. But then they go further in that because the city then explains why she was terminated. Now we're going to get back. We'll talk about McDonnell Douglas and we'll talk about burden shifting again because it's good to talk about every time.
Week. We've got to talk about McDonnell Douglas burden shifting.
Absolutely. But the reason she's terminated, just to jump ahead, the final straw is, and part of this, I was like, well, I don't have a problem with that. But the first she's hits a hydrant and she doesn't secure water. And that clearly was a problem. So she doesn't tell anyone that she didn't secure water. Now they said, she left the hydrant wrench on the hydrant. Well, I would always leave the hydrant wrench on the hydrant. I didn't get that part.
You live in a different neighborhood than I grew up in. You can't leave a hydrant. You can't.
Okay.
That's a no. The hydrant wrench goes with you.
I leave it for the next crew behind me to shut water.
That doesn't work.
Okay. In any event, not the greatest.
Not where I spent my formative years.
Yeah, but the biggest thing is she doesn't tell the firefighters that she didn't get the water source.
Yeah,
that definitely should be a terminal offense, right? No question. And she's probationary, so they look at her skills and her decision making, etc. So just very quickly, because you can almost go to any week where we talk about burden shifting. It's the McDonnell Douglas U.S. Supreme Court case. We're just going to repeat it again very quickly for everybody. First, the plaintiff has to show that she's a member of protected class. Easy to do. She has two protected classes, race and gender, right? Female, and I think being African-American. And then the burden shifts, which is also not very hard to do, but the burden shifts back then to the employer to give a reason, right? And then it shifts back, and this is where the hard part of the cases are. You really have to find that the reasons are not pretextual, that it's the valid reason, and that's why I kind of prefaced it with they had a lot of reasons to get rid of her, and it was a legitimate reason. The department doesn't have a history because they look at it, this kind of, not direct evidence, but other evidence. And it kind of says, you could look at, well, the history's always getting rid of females. The history's always getting rid of African-Americans, but she couldn't do that. And that was part of this. She claimed she had evidence, but it was not admissible, and she couldn't come back with admissible evidence. So ultimately, as against her, the city is victorious. I don't know. Why can't people just suck up? You're a bad firefighter.
Well, it's not for everybody. The job's not for everybody. And but the thing I took away from this, and I would really encourage this, if you're the chief of training in a fire department or the chief, and you're wondering, well, how do you document someone who just isn't cutting it? I mean, what level of detail do you need? Take a look at the court ruling here, because the judge outlines all of her allegations and all of the fire department's evidence that they had to rebut each and every allegations. And there was somewhere, I think, if I'm not mistaken, 110 allegations and documentation for each of them, that she's alleging that this was discrimination. And here's the department showing, no, you failed to do this, you failed to do that. And here's the documentation. So, they really a good example of where all fire departments should be when it comes to that.
Legitimate documentation, right? I mean,
absolutely,
witness statements or whatever, but legitimate, real, not pretextual.
Right. This isn't about discrimination. This isn't about how to discriminate against somebody. This is about someone who happens to be in a protected class that is not able to do the job? And how does the department manage that part of the departure of that person from the workforce without in turn creating this liability for the organization? Because let's face it, not every white male is competent, not every black female is competent,
Not every anybody.
How do you prove it? And what sort of documentation, given also that there are biases out there, how do we tease and tease out or make sure that biases aren't being part of that decision making?
Right. So, and 110 different, that's a lot of evidence against you. So yeah, I think by 30 or 40, I probably would have been looking for a new job.
You would have thought that at some point when her attorney saw the documentation that the Denver Fire Department had, that they might have said, well, this isn't quite what you told us when you met with us the first time.
Right. And look, they could have kicked her out of the academy beforehand. They let her go this long. That says a lot. And I forget if the judge makes note of this, but it says a lot when the city's tolerating you for that long. But, if as a final last straw, you don't tell your firefighters you're untruthful. It's not a skill issue. You're untruthful with what you were not able to do, right? Secure water. I'd fire you for that alone. So anyway, but good job for Denver. And that really is, that is the way. Okay. And lastly, this is not so exciting, really. It's just a thing, I guess. But in West Virginia, the city of Parkersburg was held to have violated the state's Wage Payment Collection Act in the way it calculated the pay of firefighters. It got a little confusing to me because it had a retaliation case. But the guy gets wanted to be I think the chief fire inspector. He doesn't get it. He ultimately did get it. And then it seems like he was retaliated against. But and they allege that the city constantly manipulated, interfered with, sought to change his pay. But the way it read to me was maybe it was just inaccurate because it happens to a number of firefighters, right? Not just his.
It did, yeah, and it was kind of confusing, and I hate to really go just based on news coverage because often we're getting a filtering effect here when the news media reports on a lawsuit, but I wasn't able to find anything. Certainly I wasn't able to find a copy of the decision or the rulings and so on. So,
but it makes a point. It makes a point that when you suspend or discipline or don't promote or demote somebody and they win after suing, they're getting the difference in pay, the difference in benefits, the difference in pension, right? Back pay. They're getting all of that. And that's not always easy to run and recalculate what you should be to be made whole. They're also probably getting attorney's fees, court costs, all that in this instance. So it's, if you're a employer and you think it's worth it to do that, you really better be standing on firm ground because that's going to be a pain to, to go back and redo. Maybe you don't care. You're not the payroll person, but your payroll people will hate you. And that's really it for this week.
All right, that's going to wrap it up for this week. And please, if you like what you heard today, please click like and share, and please subscribe. We're 586, I think, subscribers last time I checked. So we're really hoping to get up to 1,000. That's going to be a big, point for us. If we can get there by the end of the year, that'd be awesome. And thank you again for watching, and we'll see you for the next edition, or see you at the next edition of Fire Law Roundup.